Good morning, ladies and gentlemen. Xin chào mọi người. I hope that you're fine. Today, we are going to start our seminar on Vietnam new personal data protection law. So those who are familiar with the matter, in 2023, there was a decree 13 that was on personal data privacy and protection. And now the law has been introduced that has more clarity on the data privacy. So today's seminar will focus on two aspects. One is the practical side of data privacy, and the other one is on the compliance side of the data privacy. So we will take a look at the triangle in the sense that we talk about the compliance, commercial and operational practices, as well as that how cybersecurity is an important part of data privacy. I am Rizwan Khan, managing partner of Acclaim Vietnam, and with me, the co-presenter is Minh Nguyen, who's the special counsel from ACSV Legal. So without further ado, we will start. This is a brief introduction of what I have done in the past. So I have held different C-suite positions as a CIO, as a CFO, and other areas. My expertise are in accounting, finance, legal side, as well as very strong focus on data privacy, cybersecurity. Minh Nguyen, she's a Fulbright scholar and she has over 15 years of experience, and she has been awarded many prestigious awards, and she has done a lot of things in data sciences and other things. Okay, so the agenda for the seminar today will be 4 points, and these are practical aspects, important definitions, impact of data privacy regulation, and last but not the least is the question answers, because I'm sure that you may have a lot of question answers. Please let me know, you can hear me. Sorry, I should have asked. Those who are online, can you hear me? If anything, then just raise the point on the chat. Leave the questions on the chat as well, so we can answer them during the seminar or after the seminar. So data privacy, practical aspect. So those who are online especially, what do you think about data privacy? Maybe you can leave your thought on the chat, and then you will compare those at the end of the seminar, that whether your understanding of data privacy is aligned with what is needed from the compliance point of view as well as from the commercial point of view. So before we start, I would like to share some quotes from different people, and these are interesting one. So Edward Snowden, as some of you know him, he's one of the biggest advocate of open speech, free speech. So he mentioned that if you say that you do not care about the data privacy, is the same thing that you don't care about the free speech. So it's something that you say, it does not apply to me, but it does actually. Then Gary Kovacs, privacy is not an option. So sometimes we think that, okay, we will take care of this, but it should not be the price we accept for just getting on the internet. So it means that you have the right to have the privacy, and you should be able to access the resources online, but at the same time, the companies and organization may ask you to identify yourself. So there is a balance between the privacy and accessibility. Tim Cook, Apple, your own information is being weaponized against us with military efficiency, carefully assembled, synthesized, traded, and sold. So a lot of time we leave a lot of things on the internet without realizing. Now, I can give you some example, especially in the context of Tim Cook. So those examples are, you might have seen, I know Facebook is for the older people now. Am I right? Instagram is relatively for new people. And for if you want to look at very young people, then TikTok, right? So you might have seen that there are some people who are traveling and they show their boarding pass on the Facebook or Instagram with their full name. So it is possible that your name on Facebook is, let's say, Grace Nguyen for example, which is not the correct name, but your boarding pass shows your full name, right? So that is the name, they can pick it up. Privacy is gone. Now, then in some cases, your passport number or other information are also mentioned on the boarding pass. Now, but then when your birthday comes, usually you leave the birthday in Facebook or Instagram, and it shows that today is your birthday. And the same thing for Zalo, right? I receive, I don't know, 200 messages on Zalo saying happy birthday to me from people who send me only 2 messages every year. We talk to each other only 2 times. I send them happy birthday, they send me happy birthday. That's it. Otherwise, we don't talk to each other on Zalo that much, right? So you can imagine that your birthday shown up as well. And I think Zalo shows that you are this year old or whatever. Anyway, so the point is that your name and birthday is mentioned. Sometimes people will mention their mother's name. Or today is my mother's birthday. I love my mother so much. Or Mother's Day, this and that. Your mother name is also there. Voila. All the information is available in pieces, but you can put it together and you have the complete identity of the person that you should not be giving away on the internet. And that's exactly what Tim Cook is mentioning, right? Now, Daniel J. Solev, privacy is rarely lost in one fell sweep. It's usually eroded over time, little bits dissolving until we finally notice how much is gone, right? Now, I can give you an example. How many of you are using email before 2000? Some of you may not be born before 2000, but those who are born, how many of you are using before 2000? So in the past, it was Hotmail, Yahoo, right? At that time, creating email was very easy. Put your name and your email is done. No phone numbers required, nothing. Now, if you set up an account on Google, it asks your phone number. So you cannot say that I'm sitting in USA, but you're giving the phone number of Vietnam. They can track where you are sitting. Of course, they can track with the device. But slowly, if you look at this, your mobile phone, for example, your location is on your mobile phone all the time. Yes or no? So that means Google can track you where you are. They identify you, they track you. Even though if you say that, do not track me, it is tracking you. Right? Same as Apple, right? Apple is no exception, right? There's an interesting read I was looking at. There was a guy in UAE, his AirPod was stolen and it is found in India, right? So the AirPods, you know, the headphone of Apple, right? So it was stolen in UAE and it is found in India because somebody from India apparently stole the AirPods, and they brought it, and the AirPod is giving the signal where it is, right? So you can imagine that now you can actually track what is going on, right? So these are the things that create a lot of privacy issues. Slowly over time, we did not realize that it's only phone number, it's only location, it's only this, it's only that. So bits and pieces, and all your privacy is gone, right? If I run an AI analysis on Facebook profile, I can exactly see that who you are, what you have been doing, because the amount of data you're sharing on Facebook or Instagram or TikTok. There are AI tools that can even analyze the videos, right? So this is very scary in the sense from the data privacy point of view. And Tim Sexwell say, in the digital world, the price of silence is often your freedom, right? So the less you share on the internet, the more your data is private, right? So keep that in mind. Share as little as possible or as little as needed, and that is the key, right? Excuse me. Okay, now, so when we talk about data privacy, the first thing is cybersecurity. So cybersecurity is not about just protecting the data, but it is about protecting people and empowering them to embrace the digital world. And why so? Because when you are online, you are exposed to a lot of things. And those because nowadays, now tell me, who does not have the banking app on their phone? Who does not have the banking app on their phone? Raise your hand digitally or in person, because I know nobody will raise the hand. Everyone has the banking app on your phone, right? How difficult it is for someone to hack into your phone and use your banking app. Because I'm sure that most of you do not enter the password, you use your fingerprint. Most of you, right? Now, if you don't use password, you use fingerprint, where the fingerprint is stored, in the device or in the system. It can be gone, right? So it's just a matter of time, right? Now, cybersecurity provides the technical aspect, is looking into the technical controls of the data privacy, right? And for these are the examples. I'm not going to bore you with the technical IT details. I can explain that later on if you need, but these are the technical controls. So that established CIA triad, the triangle: confidentiality, integrity, availability. And this is the most important thing in data privacy, right? And that's, of course, cybersecurity. CIA triangle is from the cybersecurity, but data privacy also looks into this one as well. So this is something that you must maintain at all times. So what does it mean? Confidentiality. Your data is confidential, right? In the past, when you take a flight from Saigon to Hanoi, the moment you land Hanoi, you receive a message: do you need a car? Welcome to Hanoi, do you need a car? And how do they get that one? Because somebody is leaking the data to the transport companies. Integrity, that means the data that you're securing is 100% there. There's nothing changed. And availability. Availability means to make it available to people who are authorized to see that, right? If you remember in the past, you go to bank account and you ask your wife's or your husband bank account detail, and the bank teller, because they know you, they give you the details, right? Now they ask you to show the ID card or whatever, right? So that is basically the, sometimes they don't even have access to the data to everyone. They have access to the data only to the accounts that they manage. So that is CIA triad or triangle. On the other hand, data privacy is more about the governance, framework, policies, etc., that will cover that how you are going to deal with that. So cybersecurity is on the technical side, and data privacy is on the governance side. And that tells you what are the rights of the data subject. Data subject means the person from whom you are collecting the data, right? And without a strong cybersecurity, preventing unauthorized access could be challenging. So both go hand in hand. Without cybersecurity, there is no data privacy, right? There are so many cases I have seen that I was so surprised that the passwords are easily available or easily breakable, hackable. So that is a challenge. So to summarize this one, cybersecurity forms the foundational layer of achieving privacy by design, whereas data privacy is not about the data only, but the overall view of that how you are ensuring that the data is secure. So why data privacy becomes so important in Vietnam? Because of a variety of reasons. One of them is the digital transformation in recent years. So I came to Vietnam in 2008. At that time, it was very difficult to use a credit card everywhere. It's not that easy. Those who are using credit card at that time, remember, for example, in supermarket, you have to go to the counter to charge the card. They do not give they don't have the machines on every counter, right? And now today, even the parking 3,000 or 6,000 dom, you scan the QR code and you are making the payment with QR code. So digital transformation has gone up significantly in Vietnam. That is one thing. That means that you are sharing more data. Even when you are making the payment, you're sharing the data. So if the tax authorities want to see that where you are spending money, they can find out where you are spending money, right? That's why cash payment is generally considered safe, because there's no trace. But of course, digital transformation, you don't want to carry money with you, right? It increases the risk of data breaches and also identity theft and misuse of personal information. Now, From Vietnam perspective, Vietnam is trying to achieve 30% of GDP from digital economy by 2030. And that is a very ambitious goal. And Vietnam will reach there. Of course, Vietnam in terms of digital transformation is way ahead than many other countries. We take a look at this one. If you look at ASEAN region, so Singapore is on world ranking number 4. Malaysia is world ranking number 3. Thailand is world ranking number 41, and Vietnam is at 44. So Vietnam is number 4. It's a 4th place in ASEAN region and 44th place in the world in terms of global innovation index. And this has been improving day after day, right? We see that this Vietnam is becoming more innovative, so data privacy is becoming a big concern. Now, if you look at the Vietnam's digital transformation, so there is a national digital transformation program under decision number 749, where the national targets are that digital economy contribution will be around 20% of GDP by 2025 and 30% by 2030. And on the other hand, labor productivity growth will increase 7%, at least 7% annually by 2025, and at least 8% annually by 2030. And it wants to be among top 30 countries in IT competitiveness and among top 50 countries in e-government and digital economy. Now, how many of you have seen VNEID as a foreigner, especially? If you have a foreign boss or someone, it was very difficult one. There's no clarification how to get it done, right? So when the government is moving into e-government model, then the things will be different. Not necessarily difficult or easy, but different. So that's why there's a lot of information is being stored on the system, right? One of the things that I always mention is that moving to digital is good, but the problem is the data loss. How do you ensure that data is secure at multiple locations, that the data will not be lost? In the past, papers are easy, right? So apparently VNEID will have all the information in one place. Your ID card, your driving license, and every other detail, right? What will happen if the data is erased? All of a sudden, you have nothing. There is a possibility for that. It will happen or not is one thing, but there is a possibility for that. That's why cybersecurity is very important part of data privacy. Now, if you look at the privacy and security, so data protection has two pillars. One is security, which are the technical aspect and how these policies got enforced. And data privacy, which is basically the governance that includes the policy, consents, etc. So what data is important and why? And combined together, these are protected, usable data. So there are different terms here. I'm not going through each and every one because not all of you may be interested in this, not all of you may know this, but if you have any question, more than happy to discuss after the seminar. Then, if you look at further down, so then we have traditional data protection, which is the backup and other things. Then we have data security, which is again technical aspect, encryption, authentication, etc., and data privacy, which includes the legislation, policies, etc. So this is basically the infrastructure point of view, hardware and other things. This is the technical aspect, software, you can say, and these are the regulations and policies. So these will ensure that the timely availability of unspoiled data is there. So these are important things that we need to consider when we are looking into data privacy. So data privacy is not about just the legislation. It's not just about the software. It's not just about the hardware. Collectively together, that these form the basis for data privacy. So what to do next? Now we know a bit about data privacy. I'm sure that you knew this earlier, but then what to do next? So action points. Checklist, the key data protection principles that remain in every data privacy policy. And these are accountability. Lawful accountability means who is collecting the data, what they should be doing. Lawfulness, fairness, and transparency. Purpose limitation, you use the data only for the purpose that you get it for. Data minimization, collect only as much data as needed. Accuracy of the data, you need to consider storage limitation, for example, physically stored in Vietnam or somewhere else. Integrity and confidentiality, right? So these are the checklists in any data privacy framework. So we look at the data security plan and data privacy plan. So data privacy plan is more about the policies, governance, etc. Whereas data security is more about the technical aspect, right? So these are two separate things, security and privacy, but they go hand in hand. Now, if you look at this one, so the privacy, data privacy is about data privacy, data protection, whereas data security is about cyber security, data security and cyber security. So GDPR or any other privacy law, they are looking at cyber security, data protection, and data privacy, the three elements that I explained earlier. So the PDP also take into account these things. And as some of you may be aware that there's a new law coming on cybersecurity as well. There are some regulations already in place, but they are evolving. And that means that cybersecurity will become another important regulation in the coming time. So one of the things that you can work on data privacy and protection is you go for implementing ISO 27001, which is information security management systems, right? ISMS. So what does it do? ISO 27001 is the standardized sets of practices that you need to do in order to ensure that the information in your possession is secure. So for your information, a client Vietnam is ISO 27001 certified. So every time when a client comes to us and asks the question that do you have this security, that security, that security, we tell them we are ISO 27001 compliant and certified. So then there are no questions asked. So if you look into this, so it's a lower cost for client and for us. There are other benefits as well. So the most important thing, if you look at ISO 27001, it ensures that the policies and procedures are in place to ensure the information security. You are taking actions actively to ensure that there's no confidentiality breach and other thing. And the third parties or the other parties who are interested in working with you, they have the confidence that you are following the globally recognized standards. So I would recommend that as if your organization is large enough and they did not achieve the ISO 27001 certification, I highly recommend that you should go for this, because this is not just about the data, not about the certification, but it is about the mindset, how you change people to think differently. And the cybersecurity and the data privacy is not the responsibility of one person, it is the responsibility collectively for the whole organization. Everyone is important, because keep in mind that in cybersecurity, the weakest link will result in the disaster. I was reading an article just last night. One of the oldest UK company gone out of business because there's one account has the weak password and somebody attacked and controlled the data through ransomware, and then they had to pay, I think, 140 million pounds, and then they are now going out of business. It's I think 140 years old company. So they are going out of business just because of a weak password, just weak password. So that is about the practical aspect of data privacy. I will not make you wait for the compliance side of it. So we look into the Vietnamese regulation. I would ask my co-presenter Min to continue.
Thank you, Rizwan. Okay. Okay. Hi everyone. So thank you, Rizwan, for sharing the very technical part of data privacy and data protection, as well as about the cybersecurity. Now we go to the aspect of legal issues. So as a lot of you have known the information from the rumor in the market. In June 2025, the National Assembly of Vietnam enacted the law on personal data protection, and the effective date of the law is 1st January 2026. So from now until the effective date of the law on PDP, we have just about like 6 months or less than 6 months to even less than 6 months, like 5 months to prepare. And you will question like a number of you or a number of business who already take action to try to comply with Decree 13 of the government issued in 2023 will have a question of what is the difference between the law on PDP and Decree 13 on PDP, and what should be the next step that we will do if we already comply with Decree 13. So for your reference, in terms of actually, like not in term, based on the law on promulgation of legislative document, which is also a new law just introduced in 2025. Law and resolution issued by National Assembly still have the higher effect than decree issued by the government. Therefore, the law on PDP will be considered as prevailing over Decree 13 if there is any contradiction of any particular legal issue. So keep that in mind. It means like for any particular legal issue, if you see the difference between the law on PDP and Decree 13, it means that the law on PDP will trump over that particular provision in Decree 13. One thing I would like to note with you is that the law on PDP offers some special circumstance, and please keep this circumstance in mind, because if you have a good action plan for compliance, you can utilize these special circumstance to avoid the turbulence in the future. The first special circumstance is that if the processing of the personal data has been conducted on the basis of the consents from the data subject, which was obtained in accordance with Decree 13 before 1st January 2026, then there is no need to obtain the data subject consents again on or after 1st January 2026. The second special circumstance offered in law on PDP is that if the first submission of the impact assessment dossier, we have two different kind of impact assessment dossier, one related to data processing and another one related to cross-border data transfer. Then the abbreviation for these terms is like DPIA and DTIA. If those dossiers are received by the Ministry of Public Security in accordance with Decree 13 before 1st January 2026, then there will be no need to for a resubmission on or after 1st January 2026, except for the case that your business are subject to the obligation of updating the assessment dossier, and and later on I will set out some circumstances where your business are subject to the updating obligation for this kind of dossier. So why we talk about this kind of special circumstance and why I am talking about the turbulence in the future? Please bear in mind that there is a draft version of the decree on sanctioning decree on administrative sanction in the area of personal data protection. And as what you have seen in the last perhaps like 3 months, what happened with the law, with the amended law on enterprise, the concept of UBO beneficial owner was introduced the first time in the amended law on enterprise, and the amended law on enterprise was enacted in June 2026, and it is effective in 1st July. It was effective in 1st July 2026, and at that time very like at the time of 1st July 2026, there is still no guidance on the form of the notice for declaration of UBO for any company at all. But suddenly, the national portal that you conduct the licensing online will ask you to disclosure of this kind of information about the UBO before you can submit any licensing application dossier for amendment to the enterprise registration certificate. So that can be the same scenario here, that the draft law, that the draft decree on sanctioning in the area of data protection can be, can be passed, let's say like in September or October 2025, and will be effective in 1st January 2026. So we have a very short period of time here for preparation before the real storm is coming, right? So next, I want to introduce some definition before we dig deeper into certain kind of the obligation of business to meet the compliance with law on PDP and Decree 13. And of course, most of you, if you are in-house counsel or you are a data protection officer for the company, then you should have been familiar with this kind of definition. So I just touch base very briefly, but I am sure I will emphasize in the area that I think it's important for you to keep in mind. So the first definition is definition about personal data. So personal data mean the digital data or other form of information that identify or help to identify a specific individual. Then we also have then the concept of personal data will be classified in 2 different sub-concepts. The first one is the definition about the basic personal data, and the second one is the definition about the sensitive data. So basic personal data refer to personal data that reflect common identifying or background information of an individual. For example, like family name, date of birth, gender, personal photo, ID number. Sensitive personal data mean personal data associated with an individual privacy that, when being infringed upon, shall directly jeopardize the legitimate rights of such individual, and that can include like health data or personal location data. And under the law on personal protection, on personal data protection, the law made a clarification that personal data, even after being encrypted, is still considered personal data. What is mean about encrypted? It is like encrypted is when you assign like a number, a chain of number, or a chain of number combined letter for any particular data, but then it can be encoded, and then people can know people can know what data that code is represented for. But personal data, once anonymized, is no longer considered personal data. So for the anonymation, people cannot like use any different techniques to make the code be to retrieve the data from the code anymore. So that is anonymization. And therefore, personal data after anonymized is no longer personal data. So if you are still confusing between the concept of basic personal data and the concept of sensitive personal data, you can refer to the impact assessment template issued by the Ministry of Public Security, and in that template, it is like 15 page or 20 page of the template. They have the section. They have a section 3, and it lists out all the example of personal data, and it will test whether your company process or carry out cross-border transfer of such data. So you need to tick in each box which is relevant to your own company or business. So for example, like basic personal data, let's see, like it include like individual picture, it include like passport number, driver license number, and part 2, it include marital status, it includes your social insurance number or your tax identification number. For sensitive data, it will include some information, for example, like health status, ethnic origin, and your religion. So you could ask like, why we talk about like religion and ethnic origin? And remember that in the old form of ID card, of Vietnamese citizen ID card, there is always the area of declaring your religion, whether you are Jewish or whether you follow no religion. That is in the old form of Vietnamese citizen ID card. And same about the ethnic origin. It also declares whether you are king person or you are not king person. So this kind of thing, remember, if your HR team still keeps the old form of the ID card, perhaps it is now time to erase them if they are already replaced by the new form of ID card. So you will not be deemed as processing the sensitive personal information. So, okay, so the next concept I would like to touch base is personal data processing. So the only difference offered in the law on personal data protection compared with Decree 13 is that the definition of data processing will also include the activity of anonymization, and it makes sense in that case. And we also need to go through some basic concept about the different stakeholder in data processing or data transfer. So first of all, let's familiarize ourselves with the concept of data subject. So data subject refers to an individual identified by personal data. And then next concept is personal data controller, refer to any organization or individual that decide the purpose and mean of personal data processing. And more of, and basically like all of Vietnam-based company who have the role of personal data controller in most of the cases, because all company in Vietnam have the employee, right? If they sign the contract, if they don't use the third party employee, but they sign the labor contract directly with an employees, then just by that fact we can conclude that they are data controller, and they process, they determine the purpose and the mean of processing the data of their employee. Next concept is about personal data processor. It refers to any organization or individual who is contracted by the data controller to process the data in accordance with the instruction of the data controller. Next is the hybrid concept, where a company, both plays the role of data controller and data processor. Then we have the concept of data controller come processor. And the last one is the concept of third party. Third party refers to an organization or individual other than the data subject, data controller, data processor, data controller come processor, involved in the processing of the personal data in accordance with law. So to better understand this kind of concept, we just offer here a chart demonstrating the data flow. And in this chart, you will be able to visualize why different stakeholders in this data flow will wear different hats for the role under the data protection law and decree 13. So first of all, we have the center. In the center, it is a manufacturer. Let's say like your company is a manufacturer, and your company, let's go for the line number 1. The line number 1, your company signs a labor contract with employees, so the employee are the data subject. And your company also received the application for job from some employee candidate based outside of Vietnam, for example. And in both cases, your company wear the hat of data controller come processor, because when the employee or the employee candidate as the data subject provide their personal information, for example, like they including in their CV, for example, like their date of birth or their education background, family name, first name, so on and so forth. All of that kind of data, if your company process through the CV or the cover letter submitted by the candidate or the employee, it means like your company are playing the role of data controller come processor. And then we go to line number 2. So for line number 2, let's say your company as a manufacturer has a demand to test how the individual customer react to their new sample or product, for example, like new design. Your company is a furniture manufacturer. So it wants to test like how the new design, one of the design team just introduced to the market, and how the individual customer react to this kind of design. So it sign a data processing contract, and to be honest, data processing contract is just the nature of the contract. Of course, the contract will be like will have the name appearing in the paper like a service contract. Go sign it with a market survey company, for example, like Kanta or any other company, and then to collect the opinion of the customer, of the individual customer about this kind of the design. And of course, when someone when a market survey company collect the opinion of the individual customer about a particular design, there will be a processing of the contract, because in the survey form there will be like there will be the field of information requesting the individual customer to fill in, for example, the name of the customer, phone number, resident address, email address, right? And in such case, then the market survey company plays the role of data processor, because it received the instruction from the manufacturer to conduct this data collection, not on its own initiative, and therefore it is the data controller. And therefore it is a data processor. Meanwhile, the manufacturer still like the data controller. Next, we go to the line of 3A and 3B. 3A and 3B, the nature is quite similar. Any company in Vietnam, does not have the contract with the cloud or server service provider. Most of them will have, right? And when you have a contract with and also like any of your company have or never use Zoom application. Most of the company in Vietnam, I think, in the medium or big size will use Zoom. So you will have the contract with the Zoom video communication. Okay, so let's stop right there, right? So for Zoom, when let's say like when your employee send out an invitation for different business partner and stakeholder to participate in a conference, then you will collect the name and the email address of that person for sure. That is at least the two minimum requirement for someone to sign in that conference room. And by that way, you are actually asking Zoom to be the intermediary player to collect the data on your behalf. I even don't say about like the content of the conference, which can, even in the spoken word, can contain a lot of the personal data. For example, like you mentioned about the name of someone else, you mentioned about the title of someone else, you mentioned about that position of that person in a particular company. That is all about personal data, right? And so in such case, even though the contract between you and Zoom video communication is just the video conferencing service contract, ultimately Zoom processing the data on their own initiative for their own purpose, and therefore they are the third party, similar to cloud and server service provider. So next, now we talk about the we talk about some different kind of obligations set out by law on PDP and Decree 13. So the first one is about the obligation of appointment of the data protection officer or setting up the data protection department. So it will be like DPO and DPD. So the good news under the law on PDP is that it offers some exemption for certain business and company in terms of having a head count for DPO or a department to oversee data protection. So the first small and so the exemption are that small and startup enterprise are exempt from the obligation to retain a DPO or DPD for 5 years since 1st January 2026, and households, businesses, and micro enterprise are exempt from the obligation to retain DPO and DPD if the following conditions are met. First of all, they are not running business in personal data processing. Second, they are not directly processing sensitive data. And this is a question mark. This is a big question mark, because you have to classify like whether your company in all circumstances cannot avoid processing sensitive personal data or not. Because as I said with you, right, if your company still keep actually it's a simple example. If your company still collects the ID card from any employee, the ID card contains biometric data. Because remember, the chip included in the ID card, it can be decoded to check the biometric data, for example, like selfie face of the employee, or fingerprint, or iris. It's all stored in the chip in the ID card. So when you consider that your company is entitled to the exemption, just make sure that these kind of conditions are met, and whether you can meet it or not, then you need to consider that your company still need to meet the requirement on appointment of DPO or setting up the DPD. So the last condition is like your company is not processing personal data of a large number of data subject. And this is another question mark, because what means a large number? 500 individual, or 1,000 or 1 million? What is the large number? We don't know yet. We don't have an answer yet. We need to wait for a new decree guiding the law on PDP, and likely that decree will replace decree 13, and we will see what are there. The next obligation that is very burdensome under law on PDP and decree 13 is the obligation to prepare and submit the impact assessment dossier. So what must be reported? It is the data processing impact assessment, DPIA, as I said in the very early slide, and then data cross-border transfer impact assessment, DTIA. And the good news, another good news, and we are still not sure if that is the good news, because it still contains a lot of ambiguity. Is that the exemption on submission of the DPIA is applied to small and startup enterprise for 5 years since 1st January 2026, or households, business, and micro enterprise if meeting the conditions set out in the previous slide. And also it is worth noting here that whether your company can be considered as a micro enterprise or small enterprise, you need to also carefully check the definition. Normally, for small enterprise, you must have the number of employee declaring for social insurance contribution of less than 50 persons. Okay, so when the reporting obligation are triggered, all the company which are considered like personal data controller, personal data processor, personal data controller come processor, and third party will have the obligation to submit the DPIA and DTIA one time during the company's lifetime within 60 days from the date of processing the personal data or from the date of the cross-border data transfer. And then for the updating obligation, they must submit the updated version in every 6 months. If there is any change in the information declared in the templates of DPIA and DTIA, unless the change is in relation to the business line or the information related to the DPO or DPD or related to the company existence or structuring. And currently there are, like in theory and by law, there are 3 different available method of submitting the DPIA and DTIA, which is which are online submission, postal submission, and in-person submission. But until now, based on my first-hand experience and as well as what I heard from my clients and other colleagues, the online submission is still a big trouble because the technical issue of the national PDP portal most of the time, I don't say like all the time, but most of the time, and therefore until today, the viable submission method is still just the portal submission and the in-person submission. So okay, so let's see what are there in the template of the DPIA that we need to comply with. So for the DPIA, and this is just an example on how burdensome it is for for filling in and completing the DPIA, and why you need a consultant or a lawyer to do it together with you, or at least like your in-house team need to have someone with a very highly technical legal background to be able to understand all of this. So this is just one sample of the information that we need to fill in for the DPIA form. For example, like name of the organization, the tax code, type of business, address, legal representative, and that is the most easy part. Believe me, this is the most easy part because it appears like in the no, sorry, this is for the personal data processor. So okay, so this is not the information. This kind of information are not required for the company yourself, but required for the data processor who signs the data processing contract with your company. For example, like if your company use any like headhunter or market survey company, then you need to declare this information for such company, and please with the heading, you need to also submit a copy of the contract with the data processor. So when the Ministry of Public Security asks you to submit a copy of the contract between your company and the data processor, of course you have the right to redact certain part of that contract if you deem that the information is very confidential. For example, like the commercial terms, the service fee, so on and so forth. But redacting redaction take time, and you also need to be very cautious of what kind of information you want to redact and what kind of information you think you are comfortable with to disclose with the Ministry of Public Security. Okay, as for the DTIA, the data, the cross-border data transfer impact assessment form, I just copy here a part of the form that we need to fill in, and it is about the time of personal data processing or the period of personal data storage. So actually under law on PDP, the lawmaker say like after you complete your purpose of processing the data, you need to erase or destroy or delete or remove the personal data of such a person. So if we interpret of course with the exemption, but if we black and white interpret the law, it means that, for example, if you sign a labor contract with an employee and after that employee submitted the resignation letter, then you have the obligation to erase or remove or delete the personal data of such employee. But wait a minute, how about the obligation with the tax authority and different stakeholders? So basically under accounting regulation and under tax regulation, actually you should keep this kind of data about the employee for 10 years, because there can be like an occasion that the tax authority suspect your company to evade tax or pay less tax than required about the personal income tax for that particular employee. And if you erase all information of such employee, how you can defend yourself before the allegation from the tax authority or before or to prepare for their audit. So when you fill in this kind of information, the reason why you need to check with a consultant or a lawyer is that you cannot just rely solely on the law on personal data protection or Decree 13 to understand your obligation, but you need to review other laws in other areas as well to see a big picture and to smartly fill in this kind of information. Yeah, so now is the most heated part, right? And everyone actually are waiting for this part. It is about penalty and fine from the government if there is any violation. So under the law on PDP, now it is very clear that for sale and purchase of personal data protection, the fine is 10 times the revenue from the sale, or 3 billion Vietnam dong, or approximately $120,000, whichever is higher. For cross-border data transfer violation, up to the fine is up to 5% of the violator revenue of the preceding years, or 3 billion Vietnam dong. And for other kind of violation, the fine is kept at 3 billion Vietnam dong, or approximately $120,000. So that is very clear about the law on personal data protection. But remember, we still have we are still waiting for the decree on sanctioning in the area of personal data protection, and the latest draft version of the decree still have a provision that a company can be fined up to 5% of total revenue of the violator in Vietnam for the preceding year for violations such as any repeated violation in illegal collection, transfer, purchase and sale of the personal data, or any violation in personal data processing with caught disclosure or loss of personal data of 5 million Vietnamese citizens or more. So just remember that all these parts will be gone, because now they are contradicted with the law on personal data protection, and therefore we therefore likely in the next draft version of the sanctioning decree, they will have a different word on this issue to be in line with the law on PDP. Okay, so we go to the recommendation. So remember, like you have around 5 months only to prepare before the storm is coming, right? And why 5 months? You say like, okay, 5 months, I have a lot of time. Really? If you really carefully map out all different kind of obligations set out in law on PDP and Decree 13, actually that is a lot of work that you need to do. The first thing is that you need to build up your internal policy for different kind of stakeholder, and then you need to also have your SOP and different template to implement the policy. So this is so in the presentation deck right now, I just prepare. I just give you some example of the policy that you need to keep in mind. For example, like for the privacy policy only, you need to have the privacy policy to govern the conduct of your employee. Then you need to have the privacy policy to govern the conduct of your supplier, vendor, business partner. Then you need to also have the privacy policy to govern the conduct or to govern the interaction with the end consumer, individual customer, online visitor. Why I talk about online visitor? Because for some the company whose the business model is B2B business, then you don't have you don't interact directly with the individual customer, but you do have the website, and you do less individual who are interested in your business contact you through that website. In that case, you need to have a privacy policy on the website to govern the conduct of the online visitor, to make sure that the personal data you collected from the online visitor are compliant with law, and they consent for you to collect or process their data, even though they just do the surfing on the internet and in your website and on your website. So for the different template, each policy will need to be implemented by different template. For example, like for the privacy policy for employee, then you need to have the consent template on processing personal data of candidate, consent template on processing personal data of employee, consent template on processing a personal data of employee dependent. For example, like the employee children or the employee parents who don't have a salary, right? And then consent template on processing personal data of employee on video and audio recording, and then personal data protection clause in the labor contract to make sure that this is contractual. Any violation can be handled, can be deemed as a contractual breach, and can be handled through different remedy in terms of contract law. For the privacy policy for supplier, vendor, business partner, you might need to think about the template for letter of commitment on personal data protection from the supplier, vendor, business partner. And you need to also think about kind of like contract out your legal risks in personal data protection by way of putting some personal data protection related clause into the contract with your supplier, vendor, business partner. The last, and then for privacy policy for end consumer, individual customer, online visitor, you need to think about like consent template on processing personal data of them, cookie notification for the website, consent template on processing personal data of guests on video and audio recording in case of media or promotion event. And again, I should offer here an example of a consent template for you to see like how well draft you need to think about that for the template. It's not like just like a template of 3 lines and that's it, and then you comply with your obligation. No, it is actually need to be well structured, well drafted for the template to protect your interest and make sure that you comply with the law when there is any audit from the Ministry of Public Security. And that's it. We welcome any question from the audience, both in person here and participated with us online. A long question. Okay. Okay. So we received some questions both through the online registration before the event and also during the event. So we will handle. Of course, we will try to handle all of them. But if not, then we will try to catch up with you after the event. So the first question is for Mr. Annie from okay. So the question is that our company has a personnel in our headquarters in Dubai, specifically looking into personal data protection for all of our entity globally. Can this person manage the personal data compliance for our entity in Vietnam, or we are mandated to engage someone locally in Vietnam to do so? That is question number 1. And question number 2 is that what are the consequences of non-compliance with PDP in Vietnam? So for question number 1, this is actually the model of a lot of multinational company right now. They have someone in Singapore, Hong Kong, or Dubai oversees the PDP compliance in Vietnam. So under the law, basically, like just legally speaking, there is not yet any particular requirement that the data protection officer or DPO must be a Vietnamese or must speak Vietnamese language. Or what kind of the qualifications this person needs to obtain. But in the draft version of the law on PDP, there are some propositions that actually in the future there will be some exam or test or certificate that the DPO for the company in Vietnam must obtain to be qualified as the DPO. So with the current regulation that we are still waiting for more guidelines from the government, I can just say that from a practical point of view, you still need to have someone who can speak English, who can speak Vietnamese and who can write well in Vietnamese to become the DPO, to be appointed as the DPO of the Vietnamese entity. Why? Because the email address and the phone number of this person need to be shared with the Ministry of Public Security, because that is the part of the document will be required for submission of the DPIA and DTIA, the data processing impact assessment report, and the data and the cross-border data impact assessment report. And so if you have an expat sitting in Dubai or Hong Kong or Singapore to do this work, and then if there is any requirement from or request from the Ministry of Public Security, and of course they will only send the request or notification in Vietnamese, how you can react to the situation. Because remember that under both law on PDP and Decree 13, there are certain kind of remediation plan to rectify the violation that you need to carry out within 72 hours from the time of receiving the request from the MPS or from the time of detection of the violation.
And moreover, the authorities may ask the person for DPO to have VNEID, for example, because that's where the whole compliance is going towards. So that would be very challenging if someone's sitting outside, not knowing Vietnamese. And in some cases, the authorities may ask the person to visit them and then explain to them. So in that situation, yes, you can submit the Vietnamese translation, but that means there will be two-way translation going on from authorities notice from Vietnamese to English. Then you write a response to that. It comes to Vietnam, then it needs to be translated into Vietnamese and submitted. So that there are, right now, there is no requirement as such. However, there are more requirements that may come in the future. So be mindful of that as well.
Yes, so the second question of Mr. Annie is that what are the consequences of non-compliance with PDP in Vietnam? And I am sure during my presentation, I already addressed this question in a few slides of my presentation. The next question is from Mr. Mahendra. For Shopify website, the data is hosted in multi-cloud ecosystem across the world. Is that compliant to the new law? So to answer this question, we need to collect other facts as well. For example, like Shopify, does Shopify have any business partner or vendor or employee based in Vietnam? Or does Shopify even like have a representative office or branch or setting up the subsidiary in Vietnam? So we need to collect a different fact to be able to answer your question. So feel free to contact either Rizwan or me if you want to provide fact, and we can analyze your case clearer and provide the answer. Another question is from Mr. Huyền Nguyễn. We work with the third party for payroll. Please advise further action that we need to take on. So you work with the third party for payroll. In that case, the third party will be considered as a personal data processor. But you are still personal data controller, so you are still subject to the obligation of appointing a personal data officer or setting up personal data department unless your company falls into the exemption that I share in my slide deck. And you also are subject to the obligation to submit the data processing impact assessment report and data processing and data cross-border transfer report if your company have this activity.
And one more thing on top of that is that with payroll processing, it becomes more complicated because you may have dependents who are whose information is also given. So it's not just the consent of the employee, but the other things as well. So be mindful that for payroll processing, it's even more complicated than just the simple data collection. Yes.
Yeah. So next question, where can we get the template for DPIA and DTIA? It is set out in a decision issued by the Ministry of Public Security. I don't remember the date of issue, But if you need the Vietnamese version, you can contact me, and I can send the name of the decision for you, or I can send you the whole document for the decision, and the template is right there. From a question from Mr. Quang, could you give some example of third party in this case? So in the data flow chart, if you remember, I already give the example of who can play the role of third party. It can be Zoom communication company, or it can be the Google or Microsoft, who provide you with the software for Word or for Gmail or for Outlook. There are two PDP reports that a company must submit to the MPS. So with incoming PDP law, do we have to submit two other report, or actually the report are the same? Yeah, they are the same. If you already submitted under decree 13, you don't need to resubmit for the purpose of the new law on personal data protection. But if there is any update of the information in the template that you already submitted, for example, you change the data privacy officer, or you change the business line of the company, then you need to send the updated information to the MPS. Mr. Quang again, in DPIA and DTIA, MPS requested the information of the developer integrated automated platform. Could you have to give some example of this party?
Okay, perhaps I can answer this one. So when we talk about developers, so it could be anyone depending on the software that you're using. So it could be your customized payroll software. It could be ERP. It could be, for example, Microsoft Azure platform. So for well-known developers, it's pretty much obvious that you don't have to provide a lot more information. But if you develop the software with some local Vietnamese software company or some other overseas company that is not well known, then in that case you need to give more information. For example, what they have done and what are the information there. So these are the information that you need to do. But in most cases, the data storage and other things are with the well-known companies rather than the smaller companies. Smaller companies are more into the accounting software, for example, local companies, or payroll software from overseas.
So the next question should be for risk one. I have one question about GDPR compliance. Yeah. Okay. So that it means that if our company, a technology service provider based in Vietnam, successfully obtained the ISO 27001 certification, will it be considered compliant with the GDPR? We plan to provide our service to the EU, and probably will collect personal data of users in this region.
Okay, so the short answer is no, and the long answer is also no. What does it mean? It means that ISO 27001 is focusing more on the information system, information security rather than the data privacy. So 27001 will help you to go to the level where you can maintain the data privacy. However, keep in mind that all ISOs are framework, not the practice itself, because it applies to all the organization regardless of the size, regardless of the operations. Therefore, ISO 27001 will give you the foundation on which you will build the data privacy policy, data security, and cybersecurity. When you go to provide the services in Europe for complying with GDPR, you have to comply with the strict requirement of GDPR. And just for your information, GDPR is more strict than the Vietnamese PDPL. I hope it answers the question. If you still have any specific question, please feel free to contact me.
Yeah. Next question. If the headquarter parent company in the US and headquarter has a cloud contract with a third party such as Microsoft, and local Vietnam branch use that cloud service to store personal data, does the Vietnam company have to input Microsoft information into the impact assessment reports? We hope not, because the local branch just use the service, not directly sign the service contract with Microsoft. So legally speaking, you have a good case to argue here that the contract does not exist directly between the Vietnamese entity, the Vietnamese branch, and Microsoft, and therefore Microsoft is not considered as the third party in this case, because in the form of DPIA and DTIA, it declares that you only disclose when there is a contract signed directly. They not say like signed directly between whom and whom, but they just say like that you need to be disclosed if there is an existence of a contract, and we can interpret this requirement narrowly by saying that there is no existence of the contract between us, between the company, between the branch as the PD controller and Microsoft, and therefore we don't need to disclose in this case, because even we disclose, we cannot attach a copy of the contract because there will be no contract, right? The next question: we are a service vendor and sign contract with the main company to collect the company own device and process data. We understand that the employee might store the personal data on company own device. Which measure procedure that we need to follow to comply with law on PDP, and do we need the consent from the employee, the data subject, to process the data on the device, include personal data?
So yes, in that case, you have to, because your devices are used to collect the data. So although you are not the one who may be using the data, but the data subjects need to be aware of that what is being collected through the devices that are there, and then they need to know their rights, etc. And as well as, because you may not. So the short answer is that yes, you need to consider that carefully. And given the complete circumstances are not mentioned there, that what you are going to do with that data, whether you are processing it, you are storing it, or it's just because of the device. So you can share more details with us and we will be able to help you in that manner.
Yes. Okay. The next question, what is the definition of small business and startup in the case of the exemption from filing DPIA? So there is different criteria to consider whether a particular company is a small company or startup company, and they will look into, first of all, the number of the employee participating in social insurance. Second of all, they will look into the revenue, the annual revenue of that company. And the third criteria is the charter capital of that company. So there is a matrix over there for different thresholds, and you can contact me and we can provide you with more detail on the threshold. A question from Calvin: is it possible to submit only a contractual addendum to satisfy the contractual submission requirement? For instance, two parties has a supply contract with an attached addendum that contain data privacy processing term. In that case, could only the addendum be submitted? So
I think it's more about that. Some businesses may decide not to give all the information to authorities, so they may look into that okay, this is we have the data privacy, which is as an addendum, and the original contract may have certain trade secrets and other things, so you don't want to share with that. I think it would be sufficient to show that you have a contract, and then you need to give the reason that because of the trade secret, you don't want to share all the details, but you are sharing the data privacy part of that, which is as an addendum. In the beginning, my thoughts are that in the beginning it would be sufficient enough. However, authorities in the future, they may ask for the complete details. And that goes back to the question where they say that we have a US company that has the contract. So in the beginning, they may accept it, but then they may ask in the future that, okay, what is the contract between you and the parent company? Because the services are delivered and consumed in Vietnam. So then there may be other questions that may come in the future. So on the face of it, the answer is that yes, it should be okay. However, in the future, it may become more complex, which is exactly what GDPR has become. So in the past, GDPR is very simple, but now it is becoming very complex.
Yes, and just a side note that the Ministry of Public Security, after they receive the dossier of impact assessment report, they has the right to ask your company to supplement or amend different part of the report, as well as provide further document to evidence certain part you wrote over there. So basically, like the MPS has a broad discretion to decide whether they want to accept your submission or not, or they will ask you to provide. In case they ask you to provide, then you should provide to satisfy your submission obligation.
And I think there are a lot of more other questions. Unfortunately, we are running out of time. Thank you very much for joining us. And you will get the slides by email, those who have participated. And hope to see you in the next seminar soon. Thank you very much.
Thank you.